Hello, and welcome to the third session of the Constitution Unit's 2023 Summer Conference. The theme for the conference as a whole is the future of the Constitution. And in this session, we're looking in particular at courts and the rule of law. My name is Murray Hunt, and I'm the director of the Bingham Centre for the Rule of Law, and I'm your chair for this session. As you're all well aware, relations between the political branches and the courts have been strained, to put it mildly, in recent years. Pushback against the Court of Justice of the European Union and the European Court of Human Rights has spilled over into determined attempts to clip the wings of the UK's own courts. As well as a new willingness to breach or to risk breaching international law, there have been renewed interest in ouster clauses, attempts to limit judicial review of the executive, and attempts to repeal the Human Rights Act. There have been overt governmental attacks on the independent judiciary and on so-called lefty lawyers, and a failure to defend rule of law institutions against attacks in the media. All of this against a steady drumbeat of complaint that courts have become too powerful in our constitutional arrangements. The focus of this panel, in keeping with the focus of the conference as a whole, is not what has gone wrong, but how can the damage be repaired? What should be the priorities of a future government interested in restoring the UK's battered reputation as a rule of law regarding nation? What practical reforms are possible, from quick wins to more complex, longer-term reforms? And how might politicians pursue those reforms, and what might the obstacles be? To explore these matters, I'm absolutely delighted to be joined by a very distinguished panel of practical actors who are in the thick of all of these debates. First, Emily Thornberry MP. Emily has been Labour MP for Islington South since 2005 and is currently Shadow Attorney General, having held a number of very senior Shadow Cabinet positions for which the rule of law matters a great deal, including Shadow Foreign Secretary, Shadow Trade Secretary, and Shadow Secretary of State for exiting the EU. Secondly, Laura Farris MP. Laura is Conservative MP for Newbury, having been elected in 2019, and Laura and I have something in common. We're both former practising barristers at Matrix, though we didn't actually overlap in our time there. Laura has regularly made important rule of law interventions in parliamentary debates, most recently in defence of the European Court of Human Rights in the illegal migration bill, which is currently before Parliament. And thirdly, Fiona Rutherford. Fiona is Chief Executive of Justice, the law reform organisation, a role to which she brings the huge advantage of a combination of experience as a barrister and extensive government experience as a senior civil servant, having been Director of Access to Justice Policy at MOJ. Each of our speakers will make opening remarks of 5 minutes or so, after which we will have some discussion in the panel, and we will then open the floor to your questions. Questions will be gathered today by Lisa James, who you also see on your screen, Research Fellow at the Constitution Unit, who is working on the unit's important project on constitutional principles and the health of democracy. If you have a question you'd like to put to the panel, please write it in the Q&A function as opposed to the chat. Lisa will then at the right time select a broad range of questions and read them out. If you'd like to ask a question anonymously, you can indicate that when you submit your question. Can I also just note that this whole session, including the Q&A, is being recorded, and it will be posted online on the Constitution Unit's website, on its YouTube channel, and its podcast after the event. With that, let me hand over please to our first speaker, Emily Thornberry. Emily, over to you.
Sorry, Emily, you're muted.
My biggest challenge today is actually just getting some basic tech working, and I have to say I'm feeling very old. I kind of felt as though I'd got a general hang of it, but a few extra challenges and I'm just lost. Anyway, listen, thank you very much, UCL, for inviting me to join you to this panel today and for holding a discussion on these important issues. Our politics moves at such a whirlwind speed these days that we tend to spend an awful lot of time reacting to what's happening right in front of us, and probably not enough time on reflecting on what it means. I mean, politics may always have been like that, but I just feel as though it's kind of gone on steroids recently. And I think that the issues that we're discussing today are absolutely in point. Over the last few years, It feels as though we have been constantly responding to some perceived new threat to the rule of law, some new row between the executive and the court, some new attack on lawyers and judges for simply doing their jobs, or simply some new bill which appears to conflict with the UK's international legal commitments. But how often have we been able to stand back and ask ourselves questions about the true significance of these developments? For example, which of these rows is real? Which of these rows are manufactured simply for effect, almost for performance? And which are that dangerous combination of the two, a manufactured row with highly damaging consequences, which those responsible have either not thought through or don't care about? And secondly, is it all a passing phenomenon brought on by a particular set of ministers for short-term political reasons? Or is there something more systematic, reflective of genuine and unresolved problems in our constitutional settlement? And third, a subject close to home for me, but one on which I'm sure everyone will have a view, which is, what's the appropriate response from an opposition party to these new developments, both in terms of our day-to-day reactions to the latest rows, threats and attacks, and in terms of thinking long-term about what we would do differently in government? So these are some of the questions I'm looking forward to discussing today, and I'm sure that there will be many more. But just by way of some opening thoughts, I want to make two initial points, the first of which may divide opinion, and the second of which I hope will be more universally welcome. My first point, and as I say, I don't expect everyone to agree, is that I believe that these are times when the best way to win an argument with the government over these issues is not to have any argument at all. I'm not talking about the instances where they are directly attacking judges or lawyers for simply doing their jobs. They're always to be called out and criticised for the pernicious, dangerous behaviour that it is. And neither am I talking about the instances where the government is able to constrain the ability of the courts to do their jobs when it comes to the protection of rights or the scrutiny of government decision-making. Again, those attempts fundamentally and permanently alter the balance of our constitution and have to be called out and resisted. But there are other instances, some of which perhaps we'll discuss today, when it seems to me that the government is deliberately trying to generate argument about the legality of its proposed actions to avoid debate about the substance of those actions and whether those actions will do anything to address the underlying problem they're actually trying to solve. We saw that with the Northern Ireland Protocol and the Internal Market Bill. And we have seen it with various proposals to undermine human rights laws. And most obviously, and most recently, we see it in the Rwanda plan and the accompanying illegal migration bill. And they even call it the illegal migration bill. In these cases, the government has been desperate to claim that their efforts to solve the problem at hand are being thwarted by a coalition of lefty lawyers and Labour MPs. But personally, I refuse to fight them on that ground and stick to the substance of what their proposals mean instead. Why? Because if we debate and defeat them on the substance, then the legal threat will disappear. But if we spend years focusing on the legal issues, the substance will remain unchallenged. And the continuation of the underlying problem can be blamed on the courts. Now, you may disagree with that approach, but I would argue we just need to look at what happened yesterday in Parliament to see it bearing fruit. A government that had thought that the idea of scrapping the Human Rights Act and replacing it with a new Bill of Rights would lead to almighty battle in Parliament and the courts and become a central issue at the next general election. But they were instead faced with a Labour opposition which simply focused on the substance of what it would have meant in specific cases like the Hillsborough families. And as a result, the government was left with a proposed piece of legislation whose purpose they couldn't really explain, which wasn't generating the rows that they wanted to generate, which wasn't going to create an enormous mess for no political gain. And as a result, they dropped it. I don't expect everyone to agree with that approach, but I did want to explain the logic behind it before we get into our debate. Because it does take a huge amount of discipline, I can tell you, because there is nothing more that one wants to. I think you wouldn't want to do anything more than to get involved in an argument like that. But it is important to hold back. And I wanted to make another another point at the outset, or actually a promise that I hope will enjoy more unanimous support, and that's this simply. Whenever this government's time in office comes to an end, I think it is imperative that whatever state our country's constitutional arrangements are in, and whatever state the relationship between the executive and the courts, and whatever the respect for the rule of law is, we may have reached by that stage, it cannot and it must not be treated as the new benchmark against which it is the job of the next government simply to prevent further decline, because that would be a total abdication of responsibility. So just as the Labour Party has committed to repair the damage elsewhere in our legal system if we are in government after the next election, from court backlogs to victim support, so we will also be committed to repair the damage that has been done to our constitutional arrangements, to the rule of law, to the respect for the job that lawyers and judges have to do. Those norms have existed for a reason, and they need to be restored. That having been said, I look forward to hearing all of your views on how best to do that over whatever hopefully we have to do in the years to come. Thank you. And I apologise in advance for any technical problems that I have. I will keep fighting on.
Thank you very much indeed, Emily. Because we're quite short of time overall, we're going to immediately cross the floor and go straight to our second speaker, Laura Farris. Laura.
Thank you very much, Murray, and thank you very much for including me as part of this seminar. There are three assumptions in the proposition for this debate. The first is that there has been damage has been caused to the relationship between the executive and the courts, and indeed that the rule of law has at times been undermined. The second is that the best chance of repairing that lies in whatever happens after the next election. And I think it can be implied from the way it's worded that might involve a change of government. And the third perhaps is that a new political party is best placed to repair some of that. I'm going to begin actually by making some concessions. And if I was to identify what I think has been the damage that's taken place to the rule of law, I think that comes down to two things. First, the fact and reality of the Brexit referendum, and second, the character and style of a previous Prime Minister. I think if you look at everything that caused the real strain in the relationship with the judiciary and frankly to the rule of law, starting with the Miller 1 and Miller 2 litigation, then the prorogation case, then the Internal Markets Bill, which Emily referred to, and then finally the Northern Ireland Protocol Bill. All of that found its provenance in the Brexit referendum, beginning with, in fact, the question of what was the instruction from the British people? Was that an instruction that went directly to the executive and circumvented Parliament altogether? That's what Miller was intended to address, and the prorogation case. And to what extent could the government reserve itself a sort of could it arrogate to itself the right to deviate from the terms of the Northern Ireland Protocol in a way which was almost certainly in violation of international law, but nonetheless they would have said preserved the integrity of the internal market? And so part of that was, I think, the fact of a kind of insurgent campaign. But by the end, particularly with the Northern Ireland Protocol Bill, I will say without hesitation, I think that was a reflection of the type of leader that we had in Boris Johnson. So those are my concessions. The second point, though, is it is suggested in the question that the repair will only begin after the next election. And I've said I think it's implied that that may result in a change of government. I would say with great respect, I think that that task of repair has already begun. And I think that actually the character and quality of the leader of the day are sufficient to effect a reset. And I think we already see some evidence of this, both internationally and domestically. I'll start off by talking about the Prime Minister. I don't think it would have been possible for the Prime Minister to negotiate the Windsor framework not just the concessions on trading arrangements, but the very significant concession that was the Stormont break, if he didn't have a relationship of trust with Ursula von der Leyen. And I think the reason he established that is because she recognised somebody with respect for the rule of law, who was not planning to bulldoze through what had been agreed in the past. And I think you see that wasn't just a sort of isolated agreement. You see its ripple effect in the new reset in the relationship with the United States, for example. I would also say, and to be fair, I think this is something that did begin under Boris Johnson, but has crystallised in quite an impressive way in the last sort of 6 to 9 months, particularly, not just the leadership we're showing in relation to Ukraine, but through the work of the International Criminal Court, which of course has a British barrister, and the way that I think it is, funds from the UK government and leadership that's being shown in enforcing the rule of law and the sense that justice will be pursued at international level in that regard. I would also talk about the recent change to the Lord Chancellor. I'm an MP who definitely has one foot still in the bar and close connections, and I do think that his appointment has created a really important reset. And I wanted to just read you just a couple of lines from the speech he gave when he was sworn in. He was sworn in by the Lord Chief Justice in Court 4 in the RCJ, and just one little section of his speech, he was referring to a time when he'd appeared in that court and lost. And he said, "When you appear in this court, you soon realise that terms like the rule of law and access to justice aren't quaint, airy notions to pay lip service to, but the essential building blocks of a safe and fair and prosperous society. What access to justice and independence of the judiciary mean in practice is this. As you walk out of this court, having lost, you know deep down that despite your disappointment that you have been heard by judges of enormous intellect and unimpeachable integrity, and you have had a full and a fair hearing. It is hard to overstate how precious this is." And I just would also say, with the appointment of the new Attorney General, I noticed on Twitter some of the barristers I respected the most during my years in practice, like Dinah Rose, taking to social media. And I don't know what her politics are, but I do know that she's somebody who has a formidable reputation, which she deserves. And she described the new Attorney General as one of the best government lawyers that she'd ever been instructed by, and talked about the complexity and of the cases they'd worked on and her integrity. And she wasn't the only one. She just caught my eye because I knew her. So I think that we've seen with the recent appointments and the change of government a really important reset. I'm sorry, Murray, I'm not prepared to concede that point. I think that's been really significant. The other point is about the change of government, and I want to make it absolutely clear that even if, and of course I'll be absolutely horrified if this happens, but even if it were the case that Labour were to win a future general election, I don't think we should pretend that there weren't very significant flashpoints during the days in the relationship between the executive and judiciary in the days of the last Labour government. And I say this, I want to be absolutely clear, without a hint of criticism at any of the politicians I'm going to mention, because I don't share the criticisms that were levelled at them, but they were levelled nonetheless. And Murray, both you and I have worked with Cherie over the years, and I have a lot of respect for her, both particularly as a lawyer. But yet there was a fundamental issue over the lawfulness of the invasion of Iraq that went right to the heart of the question of the breach of whether it was a breach of international law. I was just revising a little bit what people said, 20 years ago during the era of the Blair government. I found it one quote, which frankly you might think could be applied to another more recent Prime Minister. He treated the rule of law as an old-fashioned inconvenience, whether it was international or domestic policy or terrorism or petty crime. That was actually Baroness Chakrabarti talking about Tony Blair. There were significant flashpoints, for example, in the 2003 Criminal Justice Bill between David Blunkett, whom I respect hugely as a member of the House of Lords, and the judiciary at the time. When he introduced the Asylum and Immigration Treatment of Claimants Act, you may recall that ouster clause, which was derided by Lord Woolf as fundamentally in conflict with the rule of law. You will also recall when the Labour government, responding obviously in the immediate aftermath of 9/11 to the threat of terrorism on these shores, they introduced the possibility, and as I say, I'm actually quite sympathetic to this, so I'm not criticising any politician, They introduced the possibility of indefinite detention without trial for foreigners suspected of involvement in terrorism, struck down by the Supreme Court as disproportionate, discriminatory and unfair. There were also big challenges when, for example, jury trials were set aside in complex fraud cases, when there was an attempt to abolish the office of the Lord Chancellor, when the then Law Lords in the House of Lords were moved to the Supreme Court. It's not a political attack line, but my point is simply this, and I'll invite people on the call perhaps to reflect on it. Perhaps it is the case, and I think it has been particularly pertinent in the last 25 years, that when it comes to international conflict or questions of immigration control or questions of criminal justice or questions of constitutional reform, there is always going to be a possibility of a tension that may exist between the executive and the judiciary, and we're perhaps naive to think that any government will neatly sidestep all of that. I could come back, and I won't because I think I've taken up a bit too much time, to the illegal migration bill, and I expect that we will come on to that. But if I was going to, I know you wanted some kind of quick wins, and I thought I would just give a quick list of what I might say. The first thing, which I think is a really important change, which all of us as parliamentarians have an obligation to think about, comes from a visit I did as a member of the Justice Select Committee to the Supreme Court, where Lord Sales said, one of the things we hear is that parliamentarians are critical of what they perceive to be judicial intervention. And he said the criticism that would gently come back from us is that you put so much stuff into secondary legislation, which has not been scrutinised, it has not been properly debated, and when it reaches us, it's not really clear what that law is meant to mean, and therefore we have to interpret it. I thought that was an excellent point, and I've made it to ministers since. I don't know if they've been listening to me. The second thing I wanted to say was I kind of half agree with Emily actually on the Bill of Rights. I would think it was the right decision. But one of the things I would actually also say is that we had a manifesto commitment to review human rights legislation. Peter Gross did that, the former Court of Appeal judge did that, and came up with a very reasoned review. So perhaps I wouldn't suggest it was quite as explosive as Emily suggested. The possibility that all laws, even those that go right to the heart of our kind of constitutional settlement, need to be kept under review is something that I would gently push back on. I also think that now that the government has paused the real bill, if I'm pronouncing it correctly, the retained EU law bill, I think one of the opportunities there, which is something they could seize quite quickly, is in this process of pausing it, is to look again at the very wide powers that have been reserved to ministers in that bill, which gives them powers for it to revoke or change or replace EU law. I appreciate some of it's been paused for now, but with minimal parliamentary scrutiny. And I think that that is something that I would like to see happen sooner rather than later. But I'll come on to the other legislation that I know we're going to discuss when we come to the Q&A. Thank you.
Excellent. Thank you very much indeed, Laura. And just to clarify, you're absolutely right that the premise of both this panel and the conference as a whole is what actions could be taken by any future government, or indeed this government, about restoring the damage that may have been done to the rule of law. So thank you very much for giving me the opportunity to clarify that. You're absolutely right. Thank you, Laura. Can I now move over to Fiona, please? Fiona.
Well, with that question very fresh in our minds, I'm going to try and answer this question as head-on as I can, considering solutions that frankly require little or no new money, because I appreciate that any government that's going to come in next year is not going to be flooded with cash, and also little or no changes to legislation, because we have a parliamentary business that is probably exceeded parliamentary business that we've seen for years to come already. And I think that there needs to be a careful look at what new legislation will come in any new government. So I've managed to think of 4 ideas that comfortably fit into this approach of little or no money and little or no legislation. But out of the 5 I'm going to summarise, I'm going to see if you can spot the one that doesn't quite meet that requirement. So number 1, The government should commit to the principles laid out in the Goa Declaration and reject the use of inflammatory language against the legal profession and the judiciary. That is something that would cost absolutely nothing to do and requires no legislation. Now, the Goa Declaration, something I must confess I was not entirely au fait with. It has only recently been signed by the Commonwealth Lawyers Association, but as part of the research I did for this event, I came across it, and I think it's worth pointing out 3 of the points in it because I think it succinctly demonstrates what sits behind this particular solution. So number 1, the independence and the impartiality of the judiciary must be upheld and protected by governments. Again, hopefully, as others have said, pretty uncontroversial, and it would be great that that is a principle that's properly embedded and is understood by all. 2, lawyers must not be identified with their clients and their clients' causes or interests as a result of performing their professional duties and functions. Again, hopefully not deeply controversial. 3, lawyers must be free to perform all of their professional duties without threats, intimidation, hindrance, harassment, or improper interference or influence. So while lawyers, and I should state this at the outset, lawyers and judges certainly are not above criticism, a general attack on the profession risks severely undermining the rule of law. And I think that's possibly, without wanting to put words into his mouth, what Murray may have been alluding to in relation to recent years. Hostile comments that attack these professions may undermine the public's perception. It's not just about how the professions feel, but it can undermine the public's perception of judicial independence as well as the motives of lawyers. And as such, government officials and parliamentarians, we all should refrain from disparaging lawyers and judges simply for carrying out their jobs. The same applies to inflammatory rhetoric about judicial review and the apparent need for government to curb judicial power. So that's my solution number 1. Solution number 2, or option number 2, is that the government should recommit to the Human Rights Act of 1998 and should strengthen awareness and public ownership of human rights as recommended by the Independent Human Rights Act review that Laura has just referenced that Sir Peter Gross chaired, a review that was established and Sir Peter Gross appointed by the government. So the Human Rights Act, sorry to state the obvious, a vital Human Rights Act enhancing piece of legislation which enables ordinary individuals to enforce their rights in UK courts and hold public authorities to high standards whilst maintaining parliamentary sovereignty. So for the government to show that it's willing to submit to adjudication before the courts on the basis of rights protected by this act sends a message to the public regarding trust in the judiciary and the importance of the rule of law. In fact, the government should welcome, in my view, the opportunity to demonstrate that its decisions and laws are compliant with human rights standards, as opposed to find ways in which to potentially circumvent. 73% of adults in the UK believe that rights, laws and protections must apply to everybody equally. That's a Comres poll that was undertaken last year, in 2021. Only 18% thinking that reviewing the Human Rights Act should be a priority for the government. We've obviously heard what happened yesterday in relation to the Bill of Rights. However, what I would say about that 18% is that it still could be indicative of a lack of knowledge of exactly what human rights does and how everybody benefits from them. And as such, I would certainly agree with Sir Peter Gross and the Independence Review's call on all authorities to take measures that strengthen human rights education. Third, the government must refrain from further attempts to undermine access to judicial review, and it must recognise that judicial review is a way for individuals and communities to hold the state to account. The courts act as a necessary check on executive action. This is an essential component of the rule of law. However, attempts to narrow the remit of judicial review suggest a disempowerment of the judiciary and through this, the public. Of course, attempts to undermine judicial review are not a new concern. We can perhaps explore that a little further later on. In short, though, I would simply repeat and concur with the Independent Review of Administrative Law, another independent review that was established under Boris Johnson's government, which considered, and I'm just going to quote, that the independence of our judiciary and the high reputation in which it is held internationally should cause the government to think long and hard before seeking to curtail its powers. So that was point number 3. Idea number 4. The government must inject investment into the justice system, both in terms of physical infrastructure and the individuals whose services provide access to justice to those who otherwise would be unable to afford it. There's the one that's not followed my aspirational approach to find ideas that cost no money and require no legislation. But just to flesh this out a little bit, the ability to access the court is needless to say, a crucial aspect to the rule of law. It allows individuals to hold public authorities accountable for the decisions that they've made. It prevents unnecessary incursions into our liberty, and it smooths the rough edges of majoritarianism by ensuring that the rights of minorities, even when unpopular, are upheld. Despite this, issues in accessing justice permeate the entirety of our justice system. Better data and understanding and appropriately deploying the power of data, transparency and technology are other elements to consider under this header. Fifthly, and to round up my 5 ideas, and we're going back to something that shouldn't really cost very much and may need very little, possibly secondary legislation, is a greater effort should be made to build a more diverse judiciary. It's essential for the rule of law that all are equal before the law. And as highlighted in, I've got to do this, I'm from Justice, I've got to plug us at some point, in one of our reports, a judiciary that reflects the ethnic, gender and social composition of the country is crucial to ensuring legitimacy in the eyes of the public and securing the court users' trust and confidence. A representative judiciary, I would suggest, would also improve the quality of decision making by bringing a broad range of judicial perspectives to the table. Murray, I will finish it there.
Thank you very much indeed, Fiona. You've certainly covered the full spectrum there, from quick wins through to more difficult and expensive reforms that may take rather longer to implement. Thank you very much indeed to all of our speakers. We'll turn shortly to audience questions in about 15 minutes or so. Thank you in the audience for all the questions you've submitted so far. If you haven't yet submitted a question, now is really the time to do so. Now you've had time to hear each of our speakers. Just please remember to put it in the Q&A function on Zoom, not in the chat. But before we get to our Q&A, let me just put a question to each of our panelists, if I may. If I can start with Emily. Emily, as Shadow Attorney General, I'm just interested in what your thoughts are about the former Attorney General, Suella Braverman's guidance on legal risk, which was one of the last acts that she took before she ceased being Attorney General. That government lawyers should not advise ministers that a law or policy is unlawful, even if there is a very high likelihood of a successful legal challenge. And I wonder whether this might be a candidate for a quick but important change if you were Attorney General.
Yeah, sure. I think I made it pretty clear at the time what I thought of the changes that she was making, so it would be pretty inconsistent of me to change her mind now. I mean, I think that, you know, and I said in my opening remarks that whatever baseline they leave us with, if we do get into power in a year's time, is not one that we should just simply adopt. We need to think about where we really should be. And I think the advice on risk is important, you know, and historically has been important. It shouldn't just be that civil servants come to us and say, yes, Minister, you know, we can argue this is lawful. We ought to be able to have better advice than that, and it ought to be on the basis of risk and on the what are the chances of us losing this case in court, because anything else is a waste of time, ministers' time, you know, the court's time, is a waste of money. We need to know, we need to have proper advice on not just, as I say, whether or not it's arguably lawful, but what the chances are of winning a case if it's challenged in the courts. And I think, I mean, I said it at the time, I just think it's completely wrong for a minister to, particularly the Attorney General, to ask government lawyers to be creative and to be imaginative and to think laterally about how it could be that we could put together an argument that it is lawful, because it's dishonest, you know, if we don't believe that it will actually win in the courts. So yes, I think it needs to be changed.
Thanks very much, Emily. I'll ask other panel members if, when I ask them their question, if they wanted to respond to any of the other responses from the other panelists. But if I can move to Laura. Laura, you've spoken very passionately in debates on the illegal migration bill, defending the European Court of Human Rights, and been one of the very experienced voices in the Commons from your legal practice. And I'm just interested in your thoughts about giving ministers the power to decide whether or not to comply with interim measures from the European Court of Human Rights, as is proposed in the illegal migration bill.
That's a very good question, Murray. Can I just begin actually by aligning myself with one of the things that Fiona said about human rights education. And if I was just going to make an observation from my 3 years in Parliament, and I probably could have inferred it before I became an MP, but it's been quite stark since I've been here. When people criticise, when MPs or journalists criticise human rights, what they're criticising is Article 8. And they're always criticising a narrow construction of it, that it militates in favour of people and considerations that somehow work against the interests of the British people. There is such a lack of understanding about the breadth of protection that the Human Rights Act offers us, and about the really important sort of dark corners of public life in which everything from, I don't know, Grenfell Tower to Hillsborough, to the positive obligations upon the police to investigate crimes against women, domestic abuse victims. That is so poorly understood across the country, and I think there's been a failure at every level, and I take responsibility for this myself as a parliamentarian, to really explain what human rights really mean in its purest sense. And I really regret that criticism of human rights is always really about Article 8. And if I hear prisoner voting mentioned one more time in the chamber, I think I'm going to explode, actually. But just going back to your question, I think the Rule 39 point is, I think it is a difficult one, because I suppose when you look at the sort of most if you're sort of in a kind of black letter law point, when the United Kingdom acceded to the European Court of Human Rights, in the document that we signed setting out our obligations, Article 46(1) obliged us to abide by a final judgment of the Strasbourg Court, and there is no sort of agreement to which we're signed up that binds us to comply with an interim measure. That is simply not in the agreement. Now, of course, the court has set in its own sort of jurisdiction that member states must, and I think it's right that we did, but I don't think it's perhaps surprising that in circumstances, going back to last summer, where the interim application had succeeded in the High Court, it had succeeded in the Court of Appeal, the Supreme Court had declined to hear the further appeal on the basis there was no discernible error of law by the Court of Appeal. It then went to Strasbourg, exercising a rule of the court, a judge, anonymous, not hearing representations at all from the government, made a decision that was contrary to that of our own domestic courts. It's not that surprising that it's created attention. And I just note that the way it's put in the illegal migration bill is not that a minister must refuse to give effect to a Rule 39 decision, but that there is a discretion to refuse it according to, for example, whether or not that judge has heard representations from the government. So I do think that Rule 39, I'd rather, to be completely honest, I'd probably rather that it was something that we reached agreement with Strasbourg on, rather than unilaterally dealing with in legislation. But I do think the scope to explore the extent of our obligations under Rule 39 is not a conversation that's off limits. And I don't think some of the criticism that was levelled was wrong, because there was such an obvious tension between even really a decision of the Supreme Court and then a judge that we have, we don't even know who that judge is, and they didn't hear any representations from us reaching a contrary decision.
Thanks very much indeed, Laura, and absolutely right that there are certainly some process questions to be asked about the Rule 39 procedure. I think there's a very interesting question, hopefully will be teased out in the Lords debates next week, about the difference between those process questions and the jurisdictional assertion that the court doesn't have the jurisdiction to give binding interim measures, as Policy Exchange have argued. So that
just to be clear, I'm not setting up a conflict between us and the European Court of Human Rights. And actually, I think in a sort of to give a more pragmatic answer, I'd like to think this is the kind of thing that could be worked through, actually, which is something we don't really sort of posit enough as a possible resolution of this issue, that there could be a dialogue with Strasbourg to see how we resolve that, because I think it's not just an issue for our government, it could affect other governments in the future, and it's not unreasonable to at least posit the question.
Thanks very much, Laura. Fiona, if I could just ask you, I know that you are very concerned about the damage that may have been done to the UK's international reputation for the rule of law and the impact that that may have had on inward investment, trade and business confidence. And I'm just wondering whether there's anything in addition to your quite comprehensive list of 5 suggestions that you think a government could do that would most powerfully signal to those audiences that the UK has drawn a line under recent more questionable behaviour in relation to its attachment to the rule of law.
The most sorry, I'm going to bit the easy route to this one is I think some of the solutions I've said, stating I think categorically the position, the government's position in relation to human rights, stating its position in relation to its compliance with the rule of law and international law as part of that. I think is those are things that as I started would cost very little. I mean, we had an event recently. We've been running a series to look at the rule of law through a range of different lenses, and we did take a perspective of the impact on the economy and what the value, I suppose, is of the rule of law on the British economy. And as I alluded to in my sort of my quick 5 minutes at the start, we underestimate that, I think, at our peril, and that was certainly the view of the panel that came to speak. That Justice also is the UK branch of the International Commission of Jurists, and I think it's fair to say that on an international scale, and this is something that's been widely spoken about, the moment we start subverting and not adhering demonstrably to these important principles, it doesn't take long for other more obviously non-compliant rights based countries such as China, for example, taking the opportunity to say, we'll do what we like, thank you very much, and you're not in a position to tell us what to do. I'm thinking specifically in relation to Hong Kong, and I'm obviously paraphrasing massively some of the commentary that's been made public. So I think it's yeah, we underestimate our peril. I think I'd leave it there. May I just make 2 quick comments in relation to the other questions, as you very kindly offered that we might do. In relation to your first question and legal risk, I thought I would just add, with a sort of my previous hat on, in relation to working in the MOJ, that in addition to the points that Emily made around, and again, sorry, I'm paraphrasing as opposed to quoting, but the importance of speaking truth to power and lawyers being able to have good working relationships with ministers. Good policy has to be lawful policy, and so you need a lawyer to tell you. Sorry, the obvious. I'm making a really obvious point. You need them to tell you if you're going to be breaking the law, or you're getting close to it, or how close to it you're going to get. So I think that I feel that very strongly is an important point of good policy development. I also think you do want lawyers to be creative, however, so your advice lawyers, the lawyers that are advising ministers, one thing I would agree with the former AG is that it can't just stop with giving a risk. You do want your lawyers to work through how you can work within the confines, as you'd expect from any lawyer in any scenario to do. And so I think that's an expectation which is entirely fair and proper to place on government lawyers. And for what it's worth, in my experience, that's I've seen very, very good examples of that. And just in relation to, I think, Laura's point, thank you for picking up the education issue or agreement with it. And I suppose I would just make the additional point here that education might be best started with maybe parliamentarians. I don't want to speak out of turn. I don't know the ins and outs of the sort of induction process of an MP, but given that the majority of parliamentarians are not lawyers and legal experts, which, by the way, I think is possibly a good thing in terms of diversity perspective, and is appropriately representative of the public. I do, with that though, you do lose some of the things that we all learn inherently as part of our legal practice about the foundation of the rule of law and what rights really mean. Yeah, I would just add that in.
Thanks very much, Fiona. Before we go to Q&A, can I just ask Laura and Emily if there's anything they wanted to add in response to any other comments made by other panelists? Emily.
I mean, I think just picking on what Fiona was saying, I think what I've always said is that it is the job of the Attorney General to be the only person around the cabinet table who can say to the Prime Minister, no, you can't do that, because it's not lawful and the rule of law applies to us all. And so I think you have to have the strength to do that, and you have to be able to stand up to the Prime Minister, and that's been the tragedy in recent years, is that we haven't had that.
Thank you, Emily. Laura, did you want to comment on anything said so far?
No, I won't comment. I do think we have that relationship between the Attorney General and the Prime Minister now.
I've got one more question for you all, actually, before we go to Lisa. And Meg has made me swear to ask you, if you had to choose one of your quick wins, what would it be? So perhaps we can do a rapid fire, choose one of your quick wins to be top of your list. Perhaps we can start with Emily.
I mean, the trouble is I just redefine what I've just said to be one win, which is to pay due deference to the rule of law. That would be good.
Thanks, Emily. Laura?
So my quick win would be to stop putting so much into secondary legislation, if I had a magic wand. But if I could just come back on one point, which I thought was excellent, that Fiona made about diversity in the judiciary. To achieve that, we need to do much more to retain a more diverse group of lawyers as they proceed through their careers at the bar. And it remains a stubborn problem that has not been solved, that there is, for example, a high level of attrition of particularly women, for example, as they reach the middle stages of their career. And there are issues, which I won't go into now, but there are issues about equal pay, which I think came out of Christopher Bellamy's review of legal aid, where he identified just at the criminal bar that there is on average a 30% pay differential between men and women at every single stage of call that I think does contribute, frankly, to the attrition rate that you see. And that has a hugely important pipeline ramification for who ends up in the judiciary. So I do think that the retention of people at the bar, recruitment and retention at the bar, is something that I would make a second priority to improve diversity in the judiciary.
Thank you very much, Laura. Fiona?
I'm a big fan of education, so I would pick the strengthening awareness and public ownership of human rights, and with that, the rule of law. I think there's nothing better than public who are making big decisions about who to vote for to understand exactly what and who they're voting for, and how the rule of law and human rights matters to the incoming government. So more of that.
Excellent. Thank you all very much indeed. So it's now time for us to open up to questions from the audience. So I'm going to hand over to Lisa, who has been keeping a beady eye on what's been coming in through the Q&A. Lisa, over to you.
Thank you, Murray, and thank you to everyone who has sent in questions. We will get through as many of them as we can. I'm going to start with a round of three covering quite a broad range of the topics that the panel have already addressed. So Steve Chaplin of the Public Law Centre in the University of Ottawa asks, would you agree that one of the driving forces is that the public has lost confidence in governments and Parliament to protect rights, and that they trust the courts to provide clear and defined protection? How do you deal with the refocusing of trust to the courts and away from Parliament, something we also see in North America? Charlie Hindhoff provocatively asks, Laura Farris argued that there's been a reset in relation to the rule of law. Has there been a reset toward human rights law? The Home Secretary under this current Prime Minister introduced a bill that was incompatible with the Human Rights Act 1998. And finally, an anonymous question. We've heard references to backlogs in the courts, challenges to legal aid funding. These are areas where questions about the rule of law come up against the nitty-gritty of public administration. What practical steps might the panel take to address these things?
Thank you very much, Lisa. I'm going to throw it open to our panelists to decide who wants to come in on which of those questions. And thank you to the audience for submitting them. Fiona, I think you're looking like you might go first.
Sorry, I'm checking. I'm not on mute. Good. Okay. Well, maybe I'll have a go at the first question around driving forces and public confidence in governments and Parliament, and whether that lack of confidence has led to pointing towards the courts where there may be a greater degree of trust. I mean, we know that there are polls that give indications of where public trust sits, which clearly does put judges, I think it's fair to say, above parliamentarians. So I suppose by saying that, I'm confirming perhaps some of the content of the question. I think my hesitation, however, is that there is very little understanding publicly in relation to terms such as judicial review, the importance behind that important, that principle and that accountability tool, and in the sort of justice system more widely, that I'm not even sure that the refocusing towards the courts is exactly what's happening from a public perspective. It's all well and good that I think a number of us who or either lawyers or academics who understand the system might see it in that sort of more binary term of moving from one point of power to another to resolve issues. But I'm not convinced that there is necessarily the more rounded view that we would like the public to have around their rights and the importance of being able to enforce. So I suppose I'm sort of slightly sidestepping the question, because I'm not sure I necessarily totally can confirm the premise within it. But I do think that it's definitely right to say that there is a high degree, a high reputation that we currently enjoy as a justice system, as a court system, as a British UK judiciary. So I think that's certainly something that may be behind the question.
Thank you, Fiona. Laura?
Yeah, if I could come in on the access to justice question, and then the one that was directed to me, which I think referred to human rights and the illegal migration bill. On access to justice, I started in practice at Matrix just at the time when the narrative around legal aid lawyers, just shortly before 2010, was sort of fat cap lawyers, and then LASPO happened, and they suffered there were very deep and sustained cuts to legal aid. And one of the things, I chair the APPG on access to justice with Karen Buck, a Labour MP, and so it's something I'm really committed to and work on a lot in Parliament. One of the things that has been pleasing, particularly in the last 12 to 18 months as we've sort of emerged from the pandemic, is the way that there has been, I think, a real return to a much better settlement on legal aid. First of all, the criminal bar, the acceptance of Christopher Bellamy's recommendations. Secondly, more recently, the really significant expansion that's happened every year really since 2020 of funding to law centres, trying to deal with what was, quite a prevalent problem when I arrived, legal advice deserts. Thirdly, the significant expansion in those who qualify, some of the most vulnerable people actually who qualify for legal aid. So, for example, new categories of domestic abuse victim who no longer, for example, have to include the value of their house in the means test for legal aid. And I could go through a number of other categories, but every incremental step to improve the accessibility of legal aid, to give people the right to pursue and vindicate and enforce their rights, has been something that has been very important to me. And I do think there has been significant progress on this issue, particularly in the last 18 months. And it's something I wrote about actually for the Bar Council during Justice Week last week. The second question, I think, was a challenge to what I had suggested, which is that I said the new Lord Chancellor and the new law officers represented a change in the government's sort of obvious manifest commitment to the rule of law and also to human rights. And I think the reference that was being made was to the illegal migration bill, which has said not that it is incompatible with our convention obligations, but that it may be. And I just wanted to, I suppose, make a couple of points on that. Emily, in her opening remarks, talked about Rwanda, and I think she said, you know, we're very against it. But the truth, for example, with Rwanda, which is obviously a slightly separate issue to the bill itself, is that that is now in the hands of the courts, and the Court of Appeal will be giving its decision on the compatibility of the Rwanda policy tomorrow. It's handing down its judgment at 10 o'clock. So I don't think we can sort of usurp the function of the court in determining that human rights issue. The second point on the illegal migration bill is that what it tries to do, I don't deny, is a radical solution, but to a problem that is profound. The reality is that in 2020, 300 people made the crossing from northern France to the south coast in small boats. Last year, that was 45,000 people. And there isn't one of those people who hasn't made that journey facilitated by a people smuggler. So if you accept the proposition that the government has got to try and get to grips with this problem, which is growing exponentially and is completely and utterly controlled by criminal gangs, then a radical solution was required. Now, this bill is still going through the Lords and the Commons, and there's an awful lot more to say about it, and I'll be speaking on it when it's next back. But I would just gently remind everybody on this kind of call panel that some of the principles in it are not new. So, for example, the principle of removal to a safe third country doesn't find its provenance with the Conservative government. That originated in the Nationality, Immigration and Asylum Act 2002, which was introduced by David Blunkett. Equally, the principle of out-of-country rights of appeal. Now, I accept those rights of appeal when they were first conceived would have meant the person could have returned to the United Kingdom for grant of asylum. But that was in the Asylum and Immigration Treatment of Claimants Act 2004. So some of these principles are rehashes of immigration attempts that other governments have made being utilised in a different way. And I think that although this bill makes no secret of the fact that it is really focused at trying to stop those routes across the channel, one of the things I would say, which I think is an important human rights consideration, and this was Tim Lawton's amendment, which has been accepted by the government, is that it will coexist with the introduction of new, safe and legal routes to the United Kingdom. So the same individual will have the opportunity to take an alternative route to the United Kingdom and make a claim for asylum, which, if granted, of course, wouldn't just give them the right to, give them a good claim for asylum, but also the right to bring their family, and ultimately the right to claim for indefinite leave to remain and to settle here permanently. But what it does do is it extinguishes that right if it's pursued through the small boat route. So from a human rights perspective, it is extinguishing a route, not a right. And I think that's a very important point of clarification to make about the bill.
Emily.
Okay. So I think just beginning at the end of what Laura said, and just starting with that, I think clearly the problem is that if the argument is that it extinguishes a route and not a right, obviously the next question is, well, in order for it to be a right at all, then how can it be exercised? Because if you extinguish that route, what route is there? And in the absence of there being any legal routes, then I think that argument just kind of falls into the sand sort of straight away, really. And although there's been talk of Bellamy, the Bellamy review, and the fact that the government belatedly accepted the recommendations of the Bellamy review, which is, to be welcomed. Obviously, there's not been anything when it comes to any equivalent increase in the level at which legal aid payments are made for solicitors. And I understand that they're judicially reviewing it, and they've had permission granted, and we'll see what happens in relation to that. But it's unfortunate, isn't it, that that the Law Society has to go to court in order to try to get that sorted out. And I hear what Laura says about the increasing in funding when it comes to access to justice, but certainly, I've had a number of visits now to law centres, to CABs, and to legal aid practitioners, and it is difficult to see that they're doing anything other than struggle, because it is a terrible struggle as far as I can see. And money is wasted. I mean, there was, as a result of the written parliamentary questions I've put in to the MOJ, I've discovered that there was a pilot scheme established to give assistance to people who were having housing-related debts, which obviously is particularly pertinent at the moment. It was £5 million, and it was spent in Middlesbrough and Manchester. And that £5 million resulted in just 3 people being given assistance. There's 3 people. So where there is money, it's not being spent properly. But I accept that, if we are given the opportunity to serve in a year's time, we will be inheriting a justice system that is, well, it's not completely on its knees, actually. And to be fair, we need to acknowledge that in the High Court and the Court of Appeal, at the higher levels of our legal system, there is not the sort of problems that you hear about in relation to what's happening in the magistrates' courts or the Crown courts or the county courts, where there are massive great backlogs. Those sorts of backlogs don't seem to occur anything like the extent. There is not the same crisis in the higher courts than there is in the lower courts, and I think that kind of needs to be said as well. And then just on Steve's point about protecting rights, I think that we also always need to remember that whenever there's any sort of problem, you always hear the same cry. People always say we need a full independent judicial inquiry, as if that is the ultimate source of truth, and and judges are the ultimate source of reliability. And I think that is important. I think that politicians should remember that. I mean, obviously, I understand that there is some kind of political hay to be made by being somehow, although you are the government and you've been the government for a very long time, somehow or other you're the insurgents. And so you have to be, even though you are the ultimate establishment yourself, to be anti-establishment. You're an anti-establishment establishment. And what you have to do is, therefore, is you have to pick fights. And so you essentially say, well, we're not the establishments, we're the insurgents, and we are fighting the blob, or we are fighting lefty lawyers, or we are fighting judges, or we are fighting the establishment and the institutions of our country. And there has been, within the sort of populist governments that we've been seeing, a tendency to do that, which is obviously immensely damaging. And I have found myself as a Labour politician who, traditionally the Labour Party was always kind of thought of as being the party that was sort of the anti-establishment one, the one that did challenge institutions, and yet we have found ourselves being the party that seems to be supporting institutions, whether it's the judiciary, the BBC, or anybody else, against a government that has been turning on it. And obviously, the judges and the legal system has caught the flack as much as anyone else has.
Let's go back to Lisa and see if we've got some more questions in the Q&A.
Thank you. Yes, we've got 3 more questions. These ones focusing on Parliament and on people. So David Corders asks, should ouster clauses and freedom for ministers to rewrite legislation, presumably this is the so-called Henry VIII clauses, both be banned? And then a couple of anonymous questions. Can we do more to improve trust in political processes to protect rights? Are there parliamentary processes that might be strengthened? Should we be thinking about perhaps enhancing the role of the Joint Committee on Human Rights so that politicians have to confront and actively take decisions about rights protection? And finally, Laura mentioned that people are all important. What qualities should we look for in a Lord Chancellor or another law officer?
Thank you, Lisa.
Can I take the last one first?
Please do, Laura.
I think that, so I actually went to an event recently, so I'm Alex Chalk's PPS, so I sort of have to follow him around to things, and the question was put, which does get put quite a lot, which is, should the office of Lord Chancellor and the office of Justice Secretary be separated, and there are arguments for and against that. But this is an observation, I'm not talking as a politician, I'm talking as a layperson. I think to command respect, because you are in charge of the judiciary, I think the Lord Chancellor should be drawn from the professions. I think that should be mandatory. And I think ideally they should be a barrister who spent many years in practice, because I think to have a sense of the sort of almost majesty of the courts, actually, and the dignity of the judicial process, yes, that involves having had in your professional life a proper kicking from a judge and a bad experience, as well as a win, and also the experience of having represented somebody in court who could not possibly have made the case that you're making on their behalf for them. And to have had all of those experiences, I think, is absolutely integral to properly discharging the role of Lord Chancellor. I have to say that. And that would, as I say, it's not really an MP's observation. That's just a lay observation that I'd make. And I think that would be, I think that would be a really good principle to have in the House. I think that the role of Attorney General shares some of the same qualities. I think really you do have to have been a practising lawyer. But I think one of the things that we're a little bit coy about admitting in Parliament is that there are very few parliamentarians, and maybe if they exist, it's possible that they're more likely to be a very experienced lawyer in the Lords, yet we tend to make them MPs, that they may not have a sort of 360 knowledge of the law, because frankly, who does? All lawyers are specialised in some way or another, and they're going to know one area better than the other. And the reality, I think, of an Attorney General in this day and age is that quite a lot of the work that they will do will be instructing counsel, external counsel who are on the sort of government panels or even beyond that in certain circumstances. And I think there could be more transparency and possibly a little less kind of coyness about what the role of the Attorney General is, who they're working with perhaps, and how the government is receiving advice at the level it does from an Attorney General. And that's not to dig at Emily at all. It's just, I think, because you're required to supply this extraordinarily high level, comprehensive range of advice, it is almost of necessity that you're going to be working more broadly, and who you work with and how you work with them is a function of that. So I think it also requires a qualified lawyer, but I'd like to see a bit more transparency about the real operation of that office. There we go.
Emily.
No, I mean, I was called to the bar in 1983, so I was practising for 20 years before becoming a member of Parliament, so I don't take it. I've had the great advantage of having two careers, I suppose. Although I think that the thing about being I think that it's right that the Attorney General is a lawyer and a politician, because I think that it is important, as I said earlier, to have somebody who is seen as a political equal and not a technocrat, but a political equal to other politicians, to explain to them as and when it is necessary that the basic. It's very annoying that the law says you can't do this. I know you want to do this, but you can't because it's not legal. The judges won't have this. I'm sorry. I know they're very annoying. I've lived with one for 40 years. They're very annoying. But they have their job and we have ours. And you have to have somebody who is a political equal who says that, and who continues to say that, whether you're in opposition or in government. It is important for politicians to have that, reminded of that. I hear what Laura says about lawyers being the Lord Chancellor. I've always been a bit surprised when people aren't lawyers and who end up as Lord Chancellor. And obviously, the famous example is Liz Truss being Lord Chancellor and the judges being under attack, and her just not understanding, I think, at that point, the importance of her stepping up and defending the judiciary at that point. But if it's important because you have to understand judges. I mean, I suppose the other point that the Lord Chancellor, the Lord Chancellor these days also, the MOJ also has responsibility for prisons and for all sorts of other things, which they, an awful lot of lawyers in Parliament won't have had any kind of experience of, certainly won't necessarily have been criminal lawyers. I'm not saying they all should have been to jail, but at least they could have been in a jail advising people, and then they might have a better understanding. I think that we don't have enough lawyers in Parliament. I say that as a joke at fundraisers where where we have a number of lawyers who are standing for Parliament for Labour, and I say this, and everybody laughs, but it's true. We don't, and actually the number of lawyers has gone down hugely as we have changed working hours in Parliament. There's a time when people used to spend their day in court and then go off to Parliament in the evening. But I think it's also changed because of the way in which we've changed our selection processes, and there's much more emphasis on members. And so, you can't just turn up and make a great speech, as lots of barristers were able to do, and then get selected by whoever happened to be in the room at the time. These days, certainly on Labour side, we have, it's the decision of the members. And so you need to be known locally to all the members. So it's much more likely that you'd be a councillor or a leader of a council to get selected. And so there's lots of council leaders, former council leaders, but not enough lawyers, in my opinion. And given that we're making law, and given that we're scrutinising law, I think that it's, and people think that there are loads of us, but there just aren't. I think it's just that when you are a lawyer and you're in Parliament, you just make that much more noise.
Actually, Michael Crick has been writing about this in his, he's got a site called Tomorrow's MPs, and he's been commenting that the current system for both of the main parties has such a local dimension that is the #1 preeminent criterion for somebody trying to be selected as a member of Parliament. And he just simply puts the question, just as you have, is that the right #1 criteria? Does it matter if, you know, they're born and bred Plymouth and they've never, you know, never been anywhere else? Should that be the thing that makes them the standout candidate?
I think that's right. And I think that the trick is to make sure that you properly understand the area that you want to represent, and to make it obvious to people that you do and that they're your first priority, but that you will also be someone who they can be proud of. I think it's getting the mixture of both of those. And a lawyer can do that, but it's harder, particularly when there's such terrible prejudice against us.
If you could be relatively quick, we need to try and wrap up at 3:45. That'd be great. Thank you.
Sure. Okay. In that case, I'll say in relation to the Lord Chancellor role, I think it's helpful to be a lawyer in that you can hit the ground running and get to grips with your portfolio probably faster and understand the context. Do I think it's necessary? No. I think what matters is somebody that, you know, cares about the justice system and putting people at the heart of it, as opposed to the way it's been designed thus far, which is primarily by judges and lawyers, if we're entirely honest, over the centuries. I'll just say one thing in relation to enhancing the role of the Human Rights Committee and greater public scrutiny. I mean, who wouldn't want better public scrutiny? I mean, I totally agree with the questioner, or the premise behind the question. And legislators now, I think, are just so, and I alluded to it earlier, up to their eyes with the level and quantity of parliamentary business. Certainly that's the feedback I get. Laura and Emily will be much better placed to comment, but the amount and volume of parliamentary business, even a lawyer, I think, would struggle to be able to scrutinise in any sort of meaningful way. And there's some really important stuff that's going through that, from a public perspective, we should really want our legislators to have the room and time to be able to do that properly, so that we have good laws at the end of the day. I'll leave it there. Thank you, Murray.
Thank you so much, Fiona. I'm glad you had a go at answering the question about what scope there is for Parliament to improve public trust as well, because I'm very tempted, as former legal advisor to the JCHR, to say there are huge ways in which Parliament has unexplored potential to enhance its role in relation to human rights, to debate it more, discuss it more. There's enormous potential really there for parliamentarians to take much more ownership over human rights in a way which hopefully in the future will make the democratic deficit argument lose its force. Well, we have come to the end of our allotted time. Before I ask you to join me in thanking all our speakers, I've just got a few quick bits of housekeeping. The recording of this session will appear on the Constitution Unit's YouTube channel and its podcast feed in the coming days. Please do subscribe to those, or look out for information on the Constitution Unit's website or Twitter. If you're not already signed up to the Constitution Unit's events mailing list, please do so in order to be the first to hear about its forthcoming events. If you just follow the Get Involved link on the Constitution Unit's website. And the next session of this conference will start tomorrow at 10:15, tomorrow morning. And the topic is elections and electoral reform. And the speakers are Cat Smith MP, Lord Hayward, John Pullinger, and Professor Sarah Birch. And I hope that you'll all be able to join us for that. The Zoom call will end in a moment, but you'll be able to join again using the same link as before, just before the next session is due to begin tomorrow morning. With that, please let me thank all of you in the audience for attending today. I would like to express my personal thanks to Mike Kenny for very generously lending me his office at the Bennett Institute, from which to chair the panel today. And let me, on behalf of you all, thank our excellent speakers today, Emily Thornberry, Laura Farris, and Fiona Rutherford, as well as Lisa James from the Constitution Unit for fielding questions, and the team behind the scenes for making everything run so smoothly. Thank you all very much. Goodbye, and we look forward to seeing you all again soon.